Hello and welcome to myself and Andrew McAulay, Clarion, having a look at specifically delay in the arena of costs activity and cost disputes. Incidentally, because he won't mention it, but Clarion is the only firm outside London to be ranked in the top tier by Chambers in their very recent ranking. So that's pretty good, and Andrew singled out for personal praise too. Anyway, delay is a big theme. Sir Rupert Jackson, who again myself and Andrew went to see a couple of weeks ago, and you can watch that interview if you want to online. Sir Rupert Jackson, one of his big themes, his overwhelming theme, was to drive delay out of litigation. Delay, it meant that witnesses, their memories faded, costs ran up, and just generally things were bad. And that's why we see a much more firm, indeed aggressive approach in civil procedure today, where delay is encountered. So Andrew now is going to look at some really recent cases, just weeks ago on delay. I want to make then a few thoughts generally about problems, in particular late budgeting, but let's throw it over to Andrew now.
Brilliant, thanks Dominic. So I'm just going to talk about three cases quickly now. The first one is a case of Gregor Fisken Limited versus Carl, very recent case. And all the cases I'm going to look at all arise out of detailed assessment proceedings. Now, in the case of Fisken, the receiving party allegedly served notice of commencement, and points of dispute were not served, and the default cost certificate was obtained for a very small sum, Dominic, of £222,000.
God, you have a good night out on that.
Anyway. But yeah, £222,000. Now, an application was made by the paying party to set aside the default cost certificate, which was successful. I'm just going to take you through just some other key points now, and feel free, Dominic, to jump in.
No, sure, of course.
So in the substantive proceedings in this matter, the paying party was represented by a firm called Davis Wolf, and what they said post the substantive proceedings were no longer acting, and they gave an email address for service by email on the defendant directly. But crucially, they didn't serve any notice of change, so nothing was filed for and nothing served.
That's bad.
The cost agent for the receiving party went on to allegedly serve the notice of commencement and documents by email, using the address given by Davis Wolf, and also tried to serve by post an address for the defendant, and neither of those methods were correct. Now, Master Leonard at the SCCO, just this is some of his wording from the judgment, said, in the circumstances, all that the claimant had to do to effect service of the notice of commencement was to send it and the appropriate supporting documents by DX or ordinary first-class post to Davis Wolf, because Davis Wolf was still on record. They hadn't come off.
Yes, yeah.
Instead, the claimant attempted to serve upon the wrong person by the wrong method, simultaneously serving by post to the wrong address. All of these errors could have been avoided with a little diligence.
Fabulous. Master Leonard is, he's brilliant, and an amazing detail. He has never once been ultimately overturned on appeal. That is a phenomenal, an enviable record for any judge in any circumstances.
Yeah. No, I echo your views there, and but look, crucial on the Fisken case, errors all evolving from a lack of understanding around service.
Sure.
CPR 6, any litigator should know that inside out.
Of course.
And ultimately, Davis Wolf never came off record. There was no need to go off in the direction they went off in.
No, and it's on a plate, isn't it? As Master Leonard effectively identifies, you just send it to them and job done. Yeah. Whether they're mean, if they're on the record, then that's it. Yeah.
Exactly. So that's the first case. Second case, case of Masten versus London Britannia Hotel Limited. And this one's from last year. But it's an important one, this one, again, because of the size of the money. I'll just take you through that now. Again, a case before Master Leonard, where he refused to set aside a default cost certificate. So the reverse of what happened in Fisken. So Fisken, it was set aside. In Masten, not set aside. DCC was for roughly £364,000. So
that's 2 good nights out.
Yeah, I was about to say, you can have a good night out on 222. You can have a very, very good night out and a few more on 364. Now, the explanation for failure to file the points of dispute, so the paying party explanation was effectively capacity. They said they were overworked, they were too busy, together with some internal administrative errors, which all led to the DCC. Yeah. 160,000. Now, crucially, which goes back to a point you said at the start, Dominic, the DCC was obtained in June 2020. The application to set it aside was not made until August 2020. Yeah. Dreadful.
Delay. Fatal. Yeah.
So definitely not prompt. So going back to one of the fundamental objectives from Sir Rupert's report was, if you do make a mistake, jump on it quickly and rectify it.
Yeah.
June to August, and what actually is quite a straightforward application to set aside a DCC. When I say straightforward, not in terms of success on it, i.e., producing the documentation. I wouldn't say it's a difficult task. It shouldn't take 2 months. And what Master Leonard said, this in judgment was, it seems to me that found to place appropriate weight on the importance of dealing with cases expeditiously, of complying with rules, practice directions and orders, and of the inevitable prejudice to the claimant on setting aside the DCC, this application must be refused.
Yeah, word perfect.
Word perfect, yeah. Now, key points what came out from the judgment as well was the importance of time limits. If you can't comply, apply in advance, prospectively reply.
Absolutely.
You can retrospectively reply, but it's not a good place to get yourself into.
Correct.
Don't be passive. Don't sit there and not do anything. Be proactive. Move forward.
And if you are indeed, Andrew, and if you are overwhelmed, then the obvious thing is to turn to somebody who can help you and lift the burden.
Yeah, definitely. And applying to set aside a DCC is not a routine administrative error. And I'll touch on that later, just some thoughts I've got on that. But ultimately, it's not a rubber stamping exercise. It's a serious application and it needs to be tracked seriously. And then the last case, Dominic, and we can have lots of good nights out on this one.
Have a week, we can have a holiday on this one. How much?
Oh, I'll tell you in a second. I'll keep you in suspense.
I'm spending the money already. Lots of bone marrow, hey?
Yeah. National Bank of Kazakhstan versus the Bank of New York, recent case, 2021. In this case, the claimants commenced detailed assessment proceedings in December 2020, and no points of dispute were served, and a default cost certificate was obtained for $3 million.
Wow, that's a lot of money.
A lot of money, serious money.
Scary money.
Yeah, 220,000, serious money. 364, serious money. 3 million, wow. Application to set aside the default cost certificate was made by the paying party, but crucially, no points of dispute were produced in support of the application. Now, a simple reading of the procedural rules, we'll see that's a key part of the application. Now, Master Roller refused the application, so the receiving party got their bill in full. Now, you imagine on a bill of that size, you would expect on detailed assessment to get some pretty serious savings, some reductions.
I mean, put another way, how often do you go on an assessment and get every single last penny or cent that you're claiming? Never, I suppose.
Never.
You're the expert, but that's my expectation.
To be fair, we've never obtained that. I don't know anyone who has, unless they get a default judgment. So, and look, I've often called it the legal cost myth, when people say you'll get back 70% of your costs on assessment. Every case is different, and you get more and less. But just if we applied that 70% on 3 million, actually, you'd expected them potentially to get reduced from the bill £900,000.
Sure.
So that cost, paying part of the ability to try and mitigate by 900,000. It's a huge amount.
Thrown away. Yeah.
Now, what Master Rowley said in this case was the absence of any points of dispute or even some outline of the points to be taken leaves me with no indication of what purpose the detailed assessment hearing would have served, except for the trial point that any detailed assessment, some costs, your point, Dominic, are likely to be reduced. That point cannot be an answer for a failure to serve points of dispute originally, as otherwise his applications would indeed be simply a rubber stamping exercise. And look, and essentially in this case explains as well the onus is on the defaulting party to demonstrate a good reason why a detailed assessment should continue. Points of dispute is a fundamental way of doing that. Now, in the first case I looked at, where it was set aside, there are obviously reasons evolving from service, and the defaulting party was able to show actually they weren't entitled to it, so it wasn't served properly.
Sure.
In these other cases, actually, service was done correctly. It all was around the ability to for points of dispute and so on. So they're the 3 cases, Dominic. And I'm just going to finish off with just some thoughts now before I pass back to you.
Sure.
Those 3 default judgments all totaled roughly 3.5 million.
Wow.
Which is a staggering number.
It is.
Only in the Fisken case was it set aside, and that one was for call it 300,000. So roughly 3.3 million in default judgments.
On the nod.
Due to procedural errors. And I just thought about this last night before obviously today doing the podcast, and I thought to myself, what I've often seen, in detailed assessment proceedings is maybe a bit more of a relaxed attitude from some representatives. So maybe treating the cost litigation not as formally as the substantive proceedings. And I think obviously when you see that, and if I'm right on that does happen, then it can lead to errors. So my key point on this is, cost proceedings are cost litigation.
They are.
Yeah, we have our own rules.
They are an adjunct to the civil procedure action, and as absolutely delay at any point, at any stage, is really serious. Yes. Yeah.
So understand the rules, the practice directions, respect the process, and if you don't, disrespect it at your peril, as you can see in these cases.
And if you're in difficulties, pass it on to somebody who can help you.
Yeah. So actually, in terms of the cost proceedings, make sure you're working with a reputable provider who understands the rules on service, and make sure we're serving properly. But remember, actually, if you're the law firm working with that cost provider, if you're on record, you're the person who still has the ultimate control and authority on that matter. So you need to make sure you're understanding what's going on and you're happy with what is happening procedurally. Make sure you're working with a provider who's got the capacity and the quality. Promptness is key. I think we've seen that. And I say it again, understand the rules of service inside out. I think, email obviously was a significant part of the day job pre-COVID. Post-COVID, electronic working has grown significantly. So everyone really should understand the rules on service by email. And, I'm seeing lots of people at the moment saying, well, I'm corresponding with you by email. That means I can serve documents on you by email. No, it doesn't.
No, it doesn't.
Yeah, have a look at the practice direction.
Sure, indeed. Okay, well, I just wanted to round off just on generally on delay. Major lapse, of course, earlier on in the process is not getting a budget in on time. And I just want a few home truths about that. So if you miss the deadline for whatever reason for filing a budget, number one, immediately produce the overdue budget. Don't think, oh, well, we'll leave it till later. Get the thing out like it's a bomb about to explode in your lap if you don't serve it. So get it out. Immediately make I can't say this often enough, a formal application to the court for relief from sanctions, and it has got to be backed up by credible witness evidence. Any application for relief from sanctions, rule CPR 3.92, it must be supported by evidence, and that evidence has got to explain what went wrong, why there was a delay, why there was a lapse, and it is imperative that there is an application. And your point about time, there are a couple of general authorities from the Court of Appeal on delay. Now, neither of these are about costs, but they are profoundly and generally applicable. So I think the one I really mention and like is a Rupert Jackson judgment called Oak Trading and British Gas. That was a case where the defendant had not filed a trial questionnaire and was subject to an unless order, and they didn't comply with the unless order. 2 days out of time, they realized their error and they produce the questionnaire, but they are now, the unless order has taken effect and they are debarred from defending. And the killer is that they waited 1 month before applying to the court for relief from sanctions. And in that judgment, Oak, as 2016, you only need to look at one paragraph, paragraph 57 of the transcript. And Sir Rupert actually said, if they'd applied on the day they spotted the error, they would definitely have been forgiven. But waiting a month rendered what was initially forgivable now unforgivable, and it was over. And so the defendant went down, 6-figure default judgment, and that was all because of delay. So it is massively important that if ever things go astray, there is a full, fast, formal application for relief from sanctions. And just a final thought, there's a High Court case last year called Heathfield, overturned, but a judge said that it is possible for the court, rather than, if a party doesn't get their budget in on time and they can't get, as it were, forgiveness, the court could impose a lesser sanction. So instead of saying, right, you're not getting any costs from now on, the court could say, perhaps, well, you'll only get 40% of your costs. And that's an interesting thought out there. And I think that's a rather clever observation from the judge in Heathfield. But I think our overall theme is that Jackson absolutely was about squeezing out delay. Rules, orders, directions are made to be obeyed, and if you miss the deadline, then you're in real trouble. So do things in time. Yeah.
Yeah, that makes sense, Dominic. Really important points there. And I don't want anyone to go away and quote me on this, just my personal view. If you get yourself into a situation where there is, for example, a default cost certificate, some kind of procedural problem, and say you found out on a Monday, I think the application should be filed at court by the Wednesday at the latest.
Agreed. Yeah. Don't let the grass grow under your feet. Absolutely.
Because you think about it, if you find out on the Monday, you work out what's gone wrong, you get client instructions, you probably spend all day Tuesday drafting it, and on Wednesday you finesse it and you send it.
Yeah.
To me, in my mind, that would be prompt. Any longer than that, potentially you start to maybe have some difficulties.
Well, indeed. Well, ultimately, whether officially or not, but we keep on going back to the Denton criteria, and moving promptly is a massive feature under stage 3 of Denton. Yes.
Yeah, that's huge.
Good.
Huge. Okay. Well, hopefully everyone's found this podcast useful. You don't tend to see many cases around default cost certificates, and I've taken you through 3 there in the last 12 months.
Well, that's why I think we thought it'd be a really good idea, because this is so hot off the press and novel, and the direction of travel from the judiciary is, even if it's a $3 million bill, the size of the bill isn't going to get you out of trouble. Yeah.
The principles are key, and the key obviously is promptness. And so just to pick on that point again, just make sure actually if you're working on any cost litigation matter, respect the process. It shouldn't be any different to the substantive litigation.
Yeah, and diarise deadlines. No,
yes.
no. Always know what's looming. Yes.
Yeah. So I hope everyone's found it useful. Just to touch on some upcoming seminars we've got. We've got a court of protection seminar this Thursday, the 1st of July. So if anyone is interested in that, still time to sign up. And then going forward, I can't remember the exact dates, but we've got a medical negligence seminar coming up over the coming months, and a serious injury seminar. So keep your look at your inbox for the invites on social media, and ultimately as well, we'll be doing lots of different podcasts on hot topics and themes over the coming months. So keep your eyes open on social media for those.